Good afternoon. So far, the focus has been on the scope of the safe harbours in the sense of the types of activity that they cover and the relationship between the safe harbours and other forms of prima facie and regulatory obligation. Now, what I've been asked to speak about is how such an intermediary may be required to act when they receive an allegation of the infringement of some kind of right or legitimate interest of a third party. These types of allegations can come from many sources, both the holders of those rights or interests and sometimes from parliamentary select committees or indeed the Speaker of the House of Commons. And the reaction of the intermediary to these allegations can be of significant public interest and in practical terms can determine in what way the rights are able to be enforced. So what I'd like to focus on in the 20 minutes I have available is four themes. Firstly, what types of remedies are we talking about? Is it just safe harbours and their interface with primary liability, or are there other kinds of notice-based remedies? Secondly, what is the standard of knowledge that the intermediary must have before they are obliged to act, if at all? Thirdly, what do we expect of them by way of response time? What does acting expeditiously mean? And finally, at a policy level, is there a justification for further or indeed any harmonisation of the notice-based remedies, and in what areas might that focus? So we think about notice-based remedies really in the context of Article 14 of the E-Commerce Directive, but also, of course, in the context of Article 13 in the caching safe harbour. And what we require is that the intermediary does not have knowledge of the relevant illegal activity or information to the required standard in order for them to rely on those safe harbours. But of course, knowledge-based remedies go far beyond the safe harbours because, as we've seen recently, the Court of Justice has outlined a knowledge-based standard in the context of hyperlinking for the purposes of imposing primary liability for copyright infringement by communication to the public. And it's very clear that that liability might be triggered by the receipt of a notice that a hyperlink is directed to an illegal or to an infringing copy of a work. Equally, in the context of defamation and other torts, the knowledge of the alleged publisher can be a relevant factor in determining whether they are taken to have impliedly acquiesced in the publication of the defamatory words. And we see that in the English courts in particular, recognising, since at least Tamis, the resurrection of an old common law doctrine by which someone who has allowed defamatory words to remain published after knowing about them can, after a reasonable period, be taken to be liable for them. Another reason why notice-based remedies are important, or why they might matter, is to seek injunctive relief. The most obvious example is service provider injunctions under Article 8.3 of the InfoSoc Directive or under Article 11 of the Enforcement Directive, where the criteria applied by the courts include a criterion of actual knowledge. So it is a jurisdictional threshold that must be surmounted in order to seek such a remedy. And in the context of other kinds of equitable duties to assist, which might be owed by some intermediaries, those duties are also triggered by knowledge of the relevant wrongdoing that they are facilitating. Of course, the list goes on. You might seek to notify someone in order to get disclosure of the identity of someone else, or in the context of the Defamation Act, Section 5, to make a notice of complaint against the website operator on whose website a defamatory comment has been published. Again, seeking to identify the person who published it. You might also be seeking to make a request as a data subject for access to your personal data, for erasure or correction of your personal data, and so on, or to withdraw your consent. And the notification of a so-called intermediary in that context might trigger an obligation to react to that request. In a more traditional commercial context, of course, the terms of service between a user and an intermediary may contain material breach provisions, which are triggered by notifying the intermediary of a breach of those terms. Finally, and perhaps most importantly, for practical purposes, individuals invoke policies which intermediaries publish by which they voluntarily remove objectionable content. This is, of course, incentivized by safe harbour protection and the requirements for that. But in practical terms, it's these private regimes for giving notices which have the most impact. There's now a form for almost everything on Facebook you can report through a kind of wizard interface any violation of copyright or trademark, and you can go through all of the relevant steps and tick the box that applies to you, and in a matter of seconds, submit your report. And this is, of course, the first stage for almost any complaint against the intermediary, but it's also, in practical terms, the way that almost 99.999% of the content is removed. There's a similar form for privacy rights violations, and the precise questions you need to answer depend on the jurisdiction in which you are based. Indeed, there are forms for a lot of other types of content that you might wish to report, in addition to the conventional use of flagging mechanisms on the platforms themselves. Google has a similar, albeit distinct, process involving another wizard which they've developed, allowing you to specify various bases for delisting indexed search results. And most recently, of course, in response to the Google Spain decision, they've made it relatively straightforward to file a request and to substantiate that request in the terms of the judgment. So the point I wanted to make in opening is really that there are a large array of different notice-based remedies beyond mere notice and takedown for the purpose of the safe harbours, and it's important not to limit the discussion just to that context. So secondly, what standard of knowledge do we expect the intermediary to have? In the context of the safe harbours, this is relatively clear, although there is some room for doubt. Article 13, which is relatively rarely invoked in practice, perhaps for good reason, it requires actual knowledge, and it's knowledge of the removal or disabling of the original content, either by the person hosting the original copy of the content or by pursuant to a court order. Article 14, however, is a slightly more ambiguous formulation. At the first stage, it requires actual knowledge of the illegal activity or information, or, where a claim for damages is being made, an awareness of facts or circumstances from which that would be apparent. Interestingly, that formulation is identical in wording to the corresponding provision of the Digital Millennium Copyright Act in the US, and it's unclear to me, perhaps others in the audience know, to what extent this was deliberate. In the UK, of course, the transposition of this wording is slightly different, and it's unclear whether anything turns on the difference. But it certainly seems to suggest a more objective standard, which perhaps approaches constructive knowledge. Of course, in practice, how is this actually to be applied? Here is, and I'm mindful that this is 9 years after the fact, still not entirely clear. Here is an ad for what purports to be a 100% genuine all-new collection L'Oreal double extension mascara. I just found it during the lunch break, so I thought it would be a useful example. It's on eBay right now. Now, if L'Oreal or if some other right holder were to complain that this is an infringement of its trademark rights, or perhaps the image is infringing someone else's copyright, how is eBay to assess this request? And is the request sufficient to confer knowledge if this is indeed a counterfeit? Because on the face of this advertisement, which eBay is hosting and perhaps promoting, it purports to be genuine. And so how is a platform or another intermediary to adjudicate a competing claim made by the uploader of this information as to its genuineness and as to the trademark proprietor as to its counterfeit nature? A more complex context might be that of licensing of broadcasts and musical works and sound recordings. Here is a video published by the Australian Broadcasting Corporation, which is archival footage of the Melbourne Olympic Games. We do have colour television in Australia now, fear not. The footage has been uploaded, it's on YouTube. Suppose that a copyright notice is received in relation to this footage. Does that confer on YouTube knowledge that this footage is infringing? You can't see in this screenshot, but it's watermarked with the ABC's logo in the bottom right-hand corner. And it's been uploaded by the ABC. So prima facie, you might say on the face of this page, it's lawful content. And certainly YouTube doesn't know any better. But if it receives an allegation, and if that allegation turns out to be incorrect, because suppose that the ABC's license didn't extend to webcasting of that content, it only extended to traditional linear broadcasting, then how is YouTube to determine that? And what level of particularity is going to confer that knowledge? So the standard that's applied, at least formally by the courts, is that set out in L'Oreal and eBay. And it's clear that this encompasses something moving beyond subjectively what the intermediary actually knew on the basis of some notification and encompasses some chain of inquiry which might vary depending on the circumstances in light of the information that's transmitted to the operator. Now, this is perhaps a little noticed aspect of L'Oréal and eBay, but it does seem to suggest that national courts, when assessing knowledge, ought to have regard to what is actually said in the notice alleging infringement. Because it may be that some notices are more detailed than others. They might attach copies of exclusive licenses, or they might substantiate ownership of rights and so on. And others might simply make a general, unparticularized allegation. But the overall question is whether it is reasonable for that intermediary to have known, based on what it was told, of the illegal information or activity. Interestingly, this does seem to leave room for different standards applying to different types of intermediaries. And this is, of course, sensible, because what YouTube or eBay might know with its team of content reviewers to examine these notices and perhaps carry out some research might be different to what a very small platform or a smaller video platform like Vimeo or a smaller marketplace like Gumtree might have the resources to investigate. And it may not be reasonable for a smaller intermediary to carry out the same kinds of steps as a larger one. On the other hand, that kind of standard needs to be applied with great care, because otherwise it could have the effect of imposing different standards of care on different intermediaries in respect of essentially the same facilitation of wrongdoing, and that might seem unprincipled. In the context of the English transposition of the e-commerce directive, we also have some mandatory factors that the courts are required to take into account, which are specified in the regulations themselves. And one of those is the contents of the notice, and indeed whether that notice was sent via the channels made available by the intermediary. Now, it seems pretty clear from looking at Facebook and Google that notices received via those channels would satisfy point A. Point B also seems likely, because the forms don't allow you to submit them unless you've filled in these details. B, subparagraph 2, is an interesting one. I've certainly been involved in disputes where the notices that have been sent fail to specify the URL of the allegedly infringing content, and it's later alleged that if the content does indeed turn out to be infringing, that notice was sufficient to confer knowledge. And the intermediary turns around and says, I think not unreasonably, how can you expect us to have searched for and found this content with any degree of confidence if you haven't actually pointed us to the specific URL? And the reason why the rights holders don't want to do that is because there might be many copies of a particular work on the platform, and they would rather just give the name of the work and say remove all the infringements. So it goes to the scope and particularity of the notice. One thing we also take from L'Oréal and eBay is that it doesn't matter how the intermediary acquires this knowledge. It might be ex officio by their own investigations, or it might be by the receipt of the notice. But it is imperative that the courts assess the quality of the notice and the level of detail that's provided. Okay, turning to a slightly different context, what about copyright and hyperlinking? I have to say that the position as articulated by the Court of Justice in GS Media is quite unsatisfactory, because we're left with, even within one judgment, a number of different expressions of the relevant mental standard. And for my part at least, I think it's totally unclear exactly what it is that the hyperlinker has to know, or is to be taken to know, and the degree of specificity with which they must know that. We see, for example, reference to the possible lack of consent of the copyright owner in relation to the target link. On the other hand, taking a fairly naive approach, one might say that upon receipt of a notification, the linker comes under some kind of a duty to inquire, and if they don't then inquire, they're to be taken to have had knowledge in the same way that they would have done had they been presumed to. But this is totally unsatisfactory. I'm not going to attempt to resolve that today, other than to point out the ambiguity. In the context of blocking injunctions, as I mentioned, there's a requirement of actual knowledge. Of course, as has been quite clearly dealt with in this jurisdiction, actual knowledge in reality boils down to receipt of the claim form and the application notice and so on, and the evidence in support of the application, and a reasonable opportunity to investigate whether or not the service is being used to infringe the relevant right. And that is by analogy with the standards of knowledge applicable to various secondary infringements of copyright in this jurisdiction. Although one wonders whether actual knowledge under EU law is an autonomous concept, or whether there is room for national concepts which apply to secondary liability. And Section 97A2 is in very similar terms to this provision, except that it omits subparagraph B3. So there are some mandatory considerations there. All right, how fast is the intermediary required to react? The starting point in the hosting and caching context is expeditiously. As we'll see, that's been subjected to a very wide degree of variation in different member states and even within the UK. In GS Media, we're not told how long the linker has to react. It appears to be from the date the notice is received, or perhaps from the very moment, and from that moment onwards they're communicating to the public. But I suggest that by analogy, perhaps with the secondary infringement cases, the linker ought at least to have a reasonable opportunity to consider the notice. In the context of defamation, we have a period to consider the notification, a reasonable period. Precisely what that means will depend on the facts and circumstances. Although, curiously, in the context of the Section 5 defence under the 2013 Act, the regulations do specify a precise period within which to respond to a notice of complaint and within which to remove allegedly defamatory material. 48 hours for the first response and 5 days after that for the removal if no response is received from the original poster. Data subject rights are also dealt with. The general principle is without undue delay, the data subject's rights must be reacted to, but in any event within 1 month of the request in the case of data access and erasure and removal. At least that's the current position in the bill, as I understand it. Right, but of course, even before removal, there may be imposed on intermediaries specific requirements to do other things, for example, to carry out these investigations. And it's clear that all of these need to be done expeditiously as well. But what does expeditiously actually require? I've just set out here a table, which I hope is visible, legible, summarising the UK defamation case law and the response time of the intermediaries in each of those cases, and then whether or not the safe harbour is applied. And it's clear that a fairly lax approach is taken to the concept of expeditiously in this country. So in some of these cases, it's difficult to form any real conclusion because there were defects in the original notice, which meant that the intermediary was taken not to have had knowledge of the allegation until the claim form was served on them many months after the original publication. But Tamitz and Google is perhaps the best of these examples for present purposes. There, the original complaint was made 5 weeks before Google ended up removing the hosted content from its Blogger service, which Mr. Justice Eadie described as somewhat dilatory, but not outside the bounds of a reasonable response. Now, if 5 weeks is considered expeditious in the context of defamation, can we extrapolate that to other areas? Or might it be the case that actually a more nuanced and granular approach is needed, such that what's expeditious in the context of defamation might not be expeditious in the context of copyright, or in the context of live streaming of sports broadcasts, for example, where the value of the work lies in the 2 or 3 hours of the live broadcast, and where expeditious might mean something very much quicker. I suggest that there's no clear answer to this at present, and it may be an area in which further harmonisation is desirable. We can contrast the English and Welsh approach with the approach taken in Northern Ireland, where the notification in the CG and Facebook Ireland case was published to Facebook on the 26th of November, and at that point the court held that they were obliged to act as a diligent economic operator in accordance with L'Oreal and eBay, and at that point, 26th November, they had knowledge of the relevant facts and circumstances showing the misuse of private information. Interestingly, the 26th November notice didn't contain all of the information they needed to know this. It was in combination with an earlier notice, which I think had been sent on the 13th of November or thereabouts, that Facebook was to be taken to know all the relevant circumstances. So it's clear that the knowledge can accumulate through a course of multiple, albeit individually defective notices. And then the content was removed on the 4th or the 5th of December. So here is a much stricter concept of expeditiously being applied by the Northern Irish courts. Just pausing there, I suggest that the discrepancy in standard of reaction is obviously undesirable for everybody, both claimants and intermediaries. It's undesirable for intermediaries because they don't know how quickly they are going to have to react, and it might differ from jurisdiction to jurisdiction or cause of action to cause of action. And it's undesirable for claimants because they don't know when their harmful content is going to be removed. One interesting comparison is with the DMCA, which uses the same standard of reaction in the general case to act expeditiously, but then in relation to counter-notifications, it imposes a very strict timetable. Once the poster of the original content that's been complained of has sent a counter-notification alleging the content is lawful to the platform, then the service provider must replace that content within 14 business days, but not earlier than 10 business days. And the reason why there's a lower limit on the reinstatement is to give the rights holder who made the complaint the chance to go to court and issue proceedings, and thereby keep the content offline pending judgment. In effect, it's a presumptive interim injunction, but no more than that. And if proceedings aren't commenced, then the content goes back up. Of course, there's no such requirement under EU law. Which brings me to future harmonisation. What could usefully be harmonised? Well, one area which seems to me to be ripe for harmonisation is what has to be within the notice. What details have to be given to the service provider, and with what degree of specificity. It would obviously be useful for a standardised format to be agreed. That way, for example, automated processing of the notices could be enhanced, and the same notice could be sent to multiple platforms without having to fill in their individual forms. So there are obvious advantages for both the complainant and the intermediary. Another area would be the means of notification. Obviously, some large online platforms are able to invest software engineer time in developing user-friendly whiz-bang wizards, but smaller intermediaries just have an email address for copyright complaints or general privacy complaints or something like that. And it would obviously be useful to have a harmonised system for delivering notifications. On the other hand, you don't want to hold back intermediaries that do have the resources to go further and offer a more streamlined system. But perhaps the most pressing area in which harmonisation seems desirable is as to the grounds of removal. So if you try and remove content from Google's organic index search results on grounds of trademark infringement, the wizard just stops you and says you can't submit the form. We don't allow removal on trademark grounds. Now that's clearly because Google's lawyers have obviously formed the view that they face very limited likelihood of being primarily or secondarily liable for trademark infringement if organic search results listing counterfeit goods remain in the index. And so they say you need to go off to court and get a court order to remove on grounds of trademark infringement. Whereas Facebook doesn't take that view. Facebook does allow complaints on grounds of trademark infringement to be filed, as I showed you in one of the screenshots earlier. So plainly there is desirability for harmonisation of what types of wrongdoing can be notified to different intermediaries, because at the moment it's totally fragmented and the decision of one intermediary as against another is completely arbitrary. Evidentiary standards, it goes to a similar point of the notice requirements and may help dealing with some of the great difficulties of assessing notifications. Response times is an obvious candidate, as is counter-notification, where obviously in order to protect the legitimate interests of the original publisher of content, there should be a reciprocal obligation to reinstate material that has been wrongfully made the subject of a takedown request. It might be said that we've got along perfectly fine for the better part of 2 decades without such a requirement in EU law, but equally everyone is aware of instances in which the facility is abused. And a related area for harmonisation might be some kind of deterrent against using notice and takedown procedures as a vehicle for unjustified reputational management or for making unjustified threats of infringement. Right, I think that's probably all I've got time for, but I just leave you with a few policy considerations. I don't have any clear answers to these, other than that in relation to each of these points that I've mentioned, there are constraints on what can legitimately be done and how that can be achieved. One of the most important policy considerations, I think, is the third one I've mentioned here. It may be the case that different procedures and different standards should apply to terrorist material and child abuse material as compared with copyright infringing material. We might regard some as a bigger problem than others, calling for a more rapid response or a different kind of response. Equally, the evidentiary standards applicable to some areas might be greater. For example, in a in the context of defamation, you might require proof that the statement is untrue for the purposes of issuing a notification, whereas in the case of copyright, you might only require proof that you own the relevant work. Right. Finally, can I just suggest that there may in fact not be as big a problem as perhaps we think at first. Although the procedures established by intermediaries might be criticised for being unaccountable, untransparent, arbitrary, and generally inconsistent, the fact remains that the large platforms do an enormous amount of work to respond to takedown requests, for the most part extremely successfully. The better part of 3.2 billion URLs have been de-indexed in the last 5 years by Google, mostly on copyright grounds. And that in and of itself is a suggestion that the system more or less is working as it should in the copyright context. Now, there may be reason to rethink that in other contexts. Just by way of example, on the 26th of February, 1.5 million URL requests were received by Google, and I think something like 99.8% of them were acted on, I think within 72 hours. On the other hand, in relation to the right to be forgotten, so-called, the number of requests is somewhat lower, and it's clear that Google chooses not to act on a majority of them in the case of requests received in the United Kingdom. So this suggests that in relation to some types of notices, it may well be appropriate for intermediaries not to act or to leave the determination to a court. And I think I'll end there. Thank you.